Hi, I'm Sara Bronin. Welcome to Property Law 101. I created this series to help you understand the basics of property law. So we cover 4 fundamental questions about property law in the series, and today we are talking about the 4th, which is holding interest in property. There are 3 basic structures for shared estates: tenancies in common, joint tenancies, and tenancies by the entirety. Today, we focus on tenancy in common, which is the most common form of shared estate. To hold land as a tenant in common means to share an undivided interest in the whole of the property. This means that each tenant has the right to possess 100% of the property. Usually, the share of income from the property or the share of burden for maintaining the property equals their percent interest. So for example, if 3 co-tenants hold a piece of property in the proportions of 9%, 5%, and 5%, the tenant with a 90% interest in the property would probably be responsible for paying 90% of the cost of the maintenance and upkeep of the property. But if they rented it to someone, they would also get 90% of the benefits. That said, co-tenants can contract around these basic principles. If co-tenants do not contribute to property maintenance, there is precedent for them to be taken into court and forced to pay. Note, however, that this gets a little bit harder if one co-tenant is occupying the property and getting all of the benefits of owning it. Along the same lines, another note for you: courts generally find that co-tenants don't need to pay rent to other co-tenants because of the undivided right of possession. The way to distinguish between various types of shared estates is to look at how tenants can exit. A tenant in common can exit the arrangement simply by selling off her interest. No special permission from the other tenants is needed to do so. Note, however, that it might be difficult to find a buyer of a portion of a shared estate. Would you want to own property with people you don't know or may not want you to co-own it with them? I doubt it. So, what happens if a tenant in common dies? That certainly is another way to exit. If that happens, she passes her interests onto her heirs. She could have a will, in which case she would designate her own heirs. She could die intestate without a will, meaning the property would pass via the applicable statute of descent. But the important point here is that there is no right of survivorship in a tenancy in common. So tenancy in common, because it's the most common form of co-ownership and because it does not have a right of survivorship that would bind subsequent co-owners and rob heirs of the property interest, courts generally tend to assume that property interests that are created by wills to groups of people are tenancies in common, absent clear language to the contrary. In the videos about tenancies by the entirety and joint tenancies, you will see a distinct difference between the way those rights are created and the way tenants can exit them. Until then, I'll leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will hope to see you next time.